Thank you, and thank you everybody for joining us for Best Practices Regarding Technology. I am your moderator, Max Stein. This webinar is a part of the Financial Poise series on legal ethics, Best Practices. Slides 7 through 10 provide a summary of the series and this episode. Speaking of the slides, you should understand from the get-go that we will not step through the PowerPoint in order necessarily, nor will you have to listen to us read any of the slides. Instead, this webinar, like all Financial Poise webinars, is intended to be a conversation. And I'm looking forward to talking with the panel about differing issues on legal ethics. Keep the PowerPoint handy, however, because I will try to indicate what slides our conversation is touching on as we proceed, and I will also try to keep the PowerPoint on those slides as much as I can. And they are a helpful reference document in the future. I've spoken about the panel, but now let me introduce them. Joining me today on the panel for today's conversation are Professor Bernie Burke, formerly of the University of North Carolina Law School, J. Eduardo Campos of Embedded Knowledge, Inc., Professor George Cooney, currently of the University of Tennessee College of Law, and Catherine Nadro from Levenfeld Pearlstein. We appreciate that you are not spending your time and money to attend this webinar to hear infomercials about us. You can read more about us, though, if you're curious, on slides 67 through 72. Thank you also to our sponsors for today's episode: Mood Hardworking Cannabis, Sunburst Digital, maker of Type to Learn, the #1 typing app for education, and Max Asset, a better way to conduct single asset sales online. This webinar is a production of Financial Poise. To sign up for our great free weekly newsletter, go to financialpoise.com/subscribe. If you are attending the live premiere of this webinar, you can submit your questions using the web portal. If you're watching online or on demand and have questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the webinar episodes, and we will do our best to get you an answer. And with the preliminaries out of the way, let's get the show on the road. Technology has long been part of the practice of law. What that means, however, has changed over the years as technology has changed, even if the lawyers might wish technology wasn't part of it all. The rapid advancement of technology and the COVID-19 pandemic have recently made issues associated with technology all the more important, as more and more lawyers have worked remotely from home and practice law primarily through electronic means. Accordingly, there are a lot of areas to address when it comes to related legal ethics and ethical concerns. And so just as at the outset, I want to note that today's conversation may be just the tip of the iceberg for some of these topics, but will hopefully provide some key tools for considering the issues. So let's get started. And Katie, I'm going to ask you to help us get started with the basics here. The model rules for professional conduct actually include provisions that relate to a lawyer's knowledge and use of technology. Can you help us get the conversation started by providing a foundation based on those rules? And here we are talking about slides 12 to 18.
Sure. And hello, everyone. Happy to be here today. So there's a general framework of the model rules of professional conduct that sort of are the basis of a lot of the different ethical guidelines that we're going to talk about today in terms of how technology will impact your legal practice. The first one that is really key to knowing all of the rest of them is the first rule in the book. It's the duty of competence. Lawyers have to be able to provide competent counsel to their clients, and to do that, they have to understand the tools they're using to provide that counsel. Comment 8 to Rule 1.1 specifically calls out the duty for attorneys to keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. That's obviously really high level, and it's intentionally written that way to expand as technology advances. I mean, we're talking about things today that we wouldn't have remotely considered relevant to the practice of law 5 or 10 years ago, AI and other tools being among those. But we have to keep up with it. We can't provide good guidance to our clients if we don't understand the technology that's out there, if we don't understand how it works and what might be involved with using those tools. So that's the fundamental rule that we have to abide by. There are other rules that are impacted by our use of technology, such as Rule 1.4, which is the duty to communicate with your clients and keep the client reasonably informed about the status of the matter. That can come into play if you're using particular technology and tools associated with the matter. So, for example, if you're going to be storing a whole lot of data for your client in a cloud-based storage system, if you're going to be either choosing to not encrypt files when you send them or to encrypt them, and you might have additional costs associated with providing one option or the other to the client, you need to explain how that's going to impact the client's representation and what risks might be associated with the different technology that you're employing. Another fundamental rule to bear in mind with technology is Rule 1.6, which is the duty of attorneys to keep information related to the representation confidential. That's our fundamental duty to our clients, is to keep all of their information confidential. And embedded in that, in Rule 1.6c, is that we have to make reasonable efforts to prevent inadvertent access to or inadvertent or unauthorized disclosure of that confidential information. When we hear that these days, we think of something like a data breach or the loss of a client's information resulting from the use of technology. If you are storing most of your confidential information for your clients, again, in some sort of cloud-based system, and there is an unauthorized access to that system, you have not kept that information confidential. And depending on whether you've used reasonable efforts to secure those systems or not, you may have committed an ethical violation. There's a series of factors that attorneys can look to in comments 18 and 19 of Rule 1.6 that talk about what might be considered a reasonable security measure when it comes to securing your system. And it's going to depend on the size and scope of your practice and your firm. But the fundamental idea here is that you can't just assume that if you're not voluntarily giving information to third parties that it's all protected and that you're abiding by your ethical obligations. You have to take reasonable efforts to secure your systems from an unauthorized access or disclosure of that data. And then we also have rules that are impacted for our duty to supervise others. Those are rules 5.1 and 5.3. Attorneys have the duty to supervise either junior attorneys working under them or non-attorney administrative support like paralegals, legal assistants, other support staff to make sure that they are also complying with our ethical obligations. With respect to technology, that means training people on the duty to keep their login information confidential as a really low-hanging fruit example, or to make sure that they are, properly redacting documents before publicly filing them online. Make sure that people aren't accidentally clicking on phishing links that could grant access to your data management system, your document management system. There's a duty that's embedded in that to provide training and policies that are going to help secure all of that information. And that needs to be conducted either firm-wide or practice-wide, because if there is a problem, it's not going to land primarily on the non-attorney staff or on your junior attorneys. It's going to land on the managing or the supervising attorney, because the buck stops with us. This is our obligation. We have the duty to make sure that everybody is following our ethical obligations as well.
Thank you, Katie. That was quite the background and the foundation, but there's a lot here. I think the overarching thing that I keep hearing, as you were talking, is all of these things are just as they ever were. The question is, what is it that you have to do to abide by those duties? The duties haven't changed. It's just that the technology means what you have to do to comply with those duties has changed. Before we go to the next topic, I want to check if anybody else wanted to share anything about these sort of foundational considerations. Bernie,
yes, there we go. I've become audible. The reasonableness standard, it's worth stressing, is an all the facts and circumstances standard. So you have to look at how sensitive the information is, how likely it is that it's at risk because people might be interested in it, illicitly looking at it. I mean, if you represent a celebrity, you probably have to be more careful than if you're representing people that nobody else have heard of. So because it's an all the facts and circumstances standard, and because technology is constantly changing, there's often a lot of uncertainty at the leading edge with new technology about how much care is reasonable care. And that's a good thing to consult with an outside expert about, in order to be consistent with the general understanding of the standard of care in the industry, or better yet, best practices.
Yes, thank you. That's certainly an excellent point about all of this does go back to legal concepts that apply even outside of this, things like reasonableness. Bernie, I wanted to actually ask you to talk a little bit about how the duty to protect data extends not just to outsiders, but also to insiders, as along the lines of what Katie was talking about at the end there. There was a relatively recent real world example of this duty playing out in a case where Proskauer Rose sued its former chief operating officer, a non-lawyer, by the way, alleging that he had downloaded over 35 gigabytes of confidential, competitively sensitive information about the firm, its partners, and its clients for use at a new job he took at a competing firm. Can you help us sort of unpack that situation, Bernie, and see how it relates to the rules that Katie helped us begin to understand?
Sure, it's a colorful case with high stakes and interesting facts. And in a lot of ways, it's a little atypical, and I'll try and explain what's atypical about it so we can focus on what's typical. As Max pointed out, the chief operating officer, Proskauer Rose, secretly accepted a new job as a high-ranking non-lawyer manager at a competing law firm. He downloaded gigantic amounts of confidential, competitively sensitive information, some of which was confidential client information, but some of which simply had to do with the business of the law firm, things that a competitor might want to know, like the revenues generated by particular partners so that you could target your efforts to poach and things like that. So the CEO then gives notice of his resignation, effective a couple of weeks hence, goes on a vacation, and then when he comes back, announces he's leaving and going to the competing law firm. Proskauer immediately brought suit, alleging theft of trade secrets, because a great deal of this was competitively sensitive business information of the law firm's business. There was a TRO and a preliminary injunction issued, keeping the COO out of the new job and preventing him from using any of the information that Proskauer was able to demonstrate through its systems that he had misappropriated. And Proskauer later added claims that this employee was really not a model worker, that he had embezzled money from his employer by having the firm pay over $150,000 in his personal expenses. And most intriguingly, preparing for his move to the competing firm, he targeted particular non-lawyer employees who he thought would benefit, that he would benefit from bringing with him to the other firm, and then worked with the CFO to systematically deny them pay raises and bonuses so they would get disgruntled and want to leave. Which, I mean, it's certainly an A for clever. I'm not sure it gets an A for anything else. The preliminary injunction was entered. The evidence was very damning, although the COO claimed he was just taking the information on vacation with him so he could continue to do his job. The parties recently settled. The terms are confidential, except that there's a stipulated permanent injunction forbidding the COO and others that were affiliated with him in this little enterprise from using any of Proskauer's proprietary information. Monetary terms, if any, were not disclosed. So it's atypical. It's not atypical to have persons in your own firm misusing or misappropriating documents or information, sometimes firm documents or information or property, sometimes confidential client information. 3 quick examples, I think they're on the slides. A bookkeeper at a small Virginia law firm embezzled $650,000 from the firm and its clients because, well, she was able to do it because she was the only person handling the firm's banking and its bank statements, including its trust accounts. No one else had looked at them for years. Interestingly, in this case, the firm is going to have to reimburse the clients for the money that was stolen from them. And 2 of the lawyers in the firm were disciplined for failure to supervise Rule 5.3, which Katie previously discussed. So there is both client liability and disciplinary liability potentially at risk here. Similarly, this is also a little bit of a pathological case. There was a non-lawyer bookkeeper at a small DC firm who pled guilty to embezzling $750,000 from the firm and affiliated businesses. He did that through inflating his own compensation and writing checks to himself that were purportedly to vendors to pay debts. That's a very common way that internal people embezzle. The shocking thing is this was happening at the same time as he was on probation after prison for having embezzled from his previous employer. Now, in the law firm's defense, excuse me, that's the next one. Morrison Forster had a similar embezzling bookkeeper or business person. He was the one who was on probation. In Morrison's defense, he had created a fake identity, apparently very skillfully, and a fabricated social security number so that it would have been very difficult to have detected this on the front end. So, what's at stake here? You have to make reasonable efforts to protect the inadvertent or unauthorized disclosure of information. It's a disciplinary and a civil duty. You also have to manage and supervise the firm and its personnel to make sure they know about procedures and practices that will safeguard the firm's information. And you need to segregate and safeguard the funds and property of clients and third persons. That's Model Rule 1.15. The comment 1 says, a lawyer should hold property of others with the care required of a professional fiduciary. So it's an especially elevated rule, and importantly, it is viewed as absolutely non-delegable, and in many jurisdictions viewed as a strict liability obligation. So saying, but I entrusted this to a bookkeeper who I reasonably believed was safe is simply no defense. Now, you have to do what's reasonably necessary depending on the nature of the property and what you're trying to do, what the client is concerned about. What can you do to prevent this kind of thing? You can't not have non-lawyer staff helping you run your law firm, whether you're a solo practice or a 1,000-lawyer international firm. You need people. So in the words of a famous ex-president, trust but verify. Proskauer, despite having been bamboozled, was able to discover the problem quite quickly because they had copy protections on all of their sensitive information, automated information technology systems that alerted different staff when those when the protection systems were overwritten, and there was careful distribution to a very limited number of people of the authority to overcome those. The CEO had to lie to and enlist the IT director to get the stuff he wanted. And even though that happened, the systems alerted others at Proskauer that this was going on. So they were able to find out what was going on really fast, take immediate action, and shut down this attempted theft of very valuable confidential information. Morrison and Forster, despite having hundreds of thousands of dollars embezzled by this person, also did a great deal right. They had comprehensive background checks on people hired into positions of trust. This was an office manager. But he engaged in elaborate identity fraud, which simply proves the unfortunate fact that we all know that no system is ever perfect. And a clever criminal will be able to find a workaround, and as soon as you shut that door, another one will be pried open someplace else. The small firm in Virginia that lost $750,000 did a great deal wrong. They didn't supervise the bookkeeper who was managing the trust accounts and the firm's money. They didn't periodically audit their trust account. They never looked at anything she was doing for years. And by the time they caught up, the money was out the door and almost certainly long gone. Now, it's easier for big firms to protect against this kind of thing because the scale allows for infrastructure, personnel, and potentially expensive protective systems. But if you're a small firm or a solo practitioner, you have the same duties as a partner at Skadden Arps does, with a whole lot less resources to protect you. So there is technology available. You need to know how it works to monitor for misuse of client files. You must, absolutely must, and a lot of small firms and solo lawyers hate doing this, but you must personally monitor your own trust accounts. That doesn't mean you have to write every check or supervise every dollar every day, but it does mean you need to take steps to ensure that things don't go missing either by error or by theft. And remember that it's not just non-lawyer personnel who can betray you. The newspapers have been full of stories about Mr. Girardi, a very famous personal injury and mass tort lawyer in California, who it turns out had been embezzling millions of dollars in client settlements from the firm's trust account for years. He is now under criminal indictment and claiming he can't be tried because he has dementia. But his firm was a small firm, and his partners are also now under scrutiny by the state bar and under scrutiny by the clients whose millions are missing to determine whether they should be disciplined, in this case likely disbarred, or held liable themselves for the losses, basically because they let Girardi do whatever he wanted and nobody ever asked any questions. And there were clients writing in saying, where's the multi-million-dollar settlement you got for me? Isn't the case over? So nothing is perfect. but you got to do your best, and especially with client or third-party property and money, you have to be extra careful, and you've got to do it. You've got to be extra careful yourself.
Indeed. Thanks very much, Bernie. Go ahead, George.
I was just going to add on Bernie's topic. The notion of having good internal controls often really means not entrusting a task like bookkeeping or data protection to a single individual, and making sure that those individuals take regular vacations, and somebody else steps into their shoes so that someone else is opening the mail and someone is seeing the secret account that's been set up. I don't know how many cases I've seen where it's the very loyal, never took a vacation church secretary who has absconded with the parishioners' money, leaving behind a bankrupt church. So I just add that in. Make sure people rotate in and out so that irregularities are caught and people ask questions.
Indeed.
Can I add something, Max?
Oh yeah,
please.
Katie,
go ahead,
go
Eduardo.
ahead, Katie. Go ahead, Katie.
I was just going to add redundancies are good in all sorts of situations, not even if it's just a bad actor, but in case somebody, God forbid, is in the hospital and is unconscious, your business can continue.
Yes, and I was going to mention, Max, that what we are talking here is about basic internal controls, nothing that sophisticated, right? It's boring, it's repetitive, it doesn't sometimes connect with the business goals, apparently, but actually they connect very well when something happens. But it's the basics. It's having backups, having a rotation, it's the old checks and balances, right? And we tend to, and I come from IT, but we tend to value all the IT apparatus, but actually the basics would solve for 80% of the issues that we face.
Indeed. You're exactly right. I mean, to the example that George made, it's as basic as making sure people take a vacation, so that you just get somebody else doing something for a little while and making sure everything's going the way it should go. George, I want to ask you, though, to talk next about some of the issues that occur when lawyers switch firms. And when making such a move, firm documents, pleadings, forms, those kinds of things can be vulnerable. Can you talk a little bit about how firms can protect what sometimes is referred to as their knowledge bank, and what statutes and public policy considerations might come into play? And here we are looking at slides 30 to 32.
Let me start off with a metaphor. I tend to view law firms in some ways as being tribes of hunter-gatherers, with individual hunter-gatherers there. We're bringing down the matter or the litigation. At the end of the year, we have a meat tear as we divide up the kill, and then we go off looking for another one. And
that is very accurate.
and sometimes a hunter wants to change tribes, and the hunter is there allowed to take with them the knowledge that they've gained at tribe number one, the tools that they have developed at tribe number one while hunting and gathering, as well as general items that are sort of, as we would say today, in the public domain. And that's really where the ABA and other ethics boards have come down. The ABA's formal opinion on this, slide 30, says that the lawyer can properly take copies of research or CLE materials, pleadings, forms, or template documents to the extent they were prepared by the lawyer or were given to the lawyer or could be considered to be in the public domain. Where you cross the line is where a departing lawyer is mining the firm's form banks, perhaps even in areas that they don't even practice in, and seeking to take that data. And that's just the legal tools side of things. Then we have the proprietary operational data that Bernie was referring to in the Protzgauer case. Those are trade secrets, and they are not something that the departing lawyer should be able to take with them. Although it's not mentioned in the slides, I think it is or should be possible to raise the bar on what a departing lawyer must leave behind by contract. It's not something that we can impose in any other way. We do have sort of protected the mobility of lawyers by prohibiting non-competes within the profession and the like. But we can definitely protect our trade secrets in that fashion. And then by following up with them promptly if we think, as in the Proskauer case, something has gone awry.
Excellent. Thank you, George. Katie, picking up on that last point that George is talking about, can you talk a little bit about how data privacy and data security and employment law intersect?
But
Sure.
before Katie starts, could I just jump in? The law on non-competes among lawyers varies from jurisdiction to jurisdiction. Some states ban it outright. A number allow it if it's quote unquote reasonable and doesn't unreasonably restrict the departing lawyer's mobility. So your mileage may differ and you need to check the law in your jurisdiction. And if you violate the restrictions of your state, not only is it subject to being voided as against public policy, but it's also a disciplinary violation for restricting the future practice of a lawyer. Sorry to interrupt.
Thank you. Katie?
Sure. So at a very high level, there is a significant amount of overlap in the compliance focus side of both data privacy and security and employment law. And it helps to think about a law firm just like you would any other business in this sense. So for law firms, you're going to have employees, and some of those are going to be attorneys who have ethical responsibilities, and some will be non-attorneys over whom you have ethical responsibilities, as we've mentioned, to ensure that they are also acting in accordance with our ethical rules. When it comes to either your data privacy program or your data security program and other employment compliance obligations, both of those are going to involve supervising people who are junior to you, apprenticeship issues, and appropriate training to make sure that you're complying with employment laws and you're complying with data security and privacy obligations. And they're both really part of the practice management aspect of running a law firm, just like you would any other business. So you have to make sure you have policies and procedures that are going to protect the privacy of your data, the security of your data, which again implicates ethical rules regarding confidentiality and supervision. And you also need to make sure that people are not violating other employment law issues like any anti-harassment policies that you need to put in place, proper use of firm equipment, both for technology issues, but also, as we've heard, accessing data that you're not supposed to access, making sure that you're keeping files where they're supposed to be kept, and really just the general oversight and compliance on both of these fronts. And so there's a lot of overlap in those issues. Also, when you consider the fact that employees are going to have privacy rights as well. If a law firm has employees, it's going to have HR data on those employees, like social security numbers, health information, things of that nature. So you have an additional obligation to your employees as well as your clients to make sure that you're securing that data.
Excellent. Thank you, Katie. So we're going to transition a little bit further or deeper, I guess I should say, into some of the technology. And Eduardo, we're going to turn to you. You happen to be our resident non-lawyer tech expert. And I wanted to ask you to help us understand about some of the new technology that's being used to monitor employees and those kinds of things.
Sure. And I want to invite my lawyer colleagues here in this panel to interrupt me at any time, because I want to share.
Don't worry, Eduardo. Lawyers are very good at that.
Not only what I usually teach at the university, at grad school, but also what I part of the research that I did preparing for this panel to see what else is out there and that relates to law firms and lawyers. But I wanted to start with a context. There's an interesting survey I shared with my peers here that is a survey done by VMware, a large tech company, about this new world of work. They call the virtual floor plan. And one statistic that I got, and we have law firms included because professional services firms are there, is that when asked about using monitoring software to survey employee productivity, 70%, 70% of the respondents said that they are either using or plan to do so. So that's interesting because after especially with the pandemic and following the pandemic, employers started seeing many more employees working remotely, and they started the ones that were not monitoring communications and so on. And I'm going to talk a little bit about the software that is used for that. Started doing so. The thing is, when I was reading the literature about it, and written by lawyers, most of them, it's one lawyer asked a client, why are you monitoring? Because I can do it. So it's not about because you can do it, you do it, right? It's what is the purpose? What is the goal? What is the policy behind it? Is it transparent? It is something that everybody knows about, or it's only for the frontline employees. The higher ups are not being monitored. That can come up in any questioning later if of the practice. The other thing is some are against, some are for. Most of employees in the US, we are talking explicitly about the US, outside the US, Europe and other geographies is going to be different. Most of the employees in the US, they expect being monitored. But the thing is that is going to turn some of them off is the lack of transparency. And most of the articles I've read, they talk about the sense of fairness that the employees must feel that it's being fair. And like Katie mentioned, the risks that are associated with monitoring, where you might be collecting data that is sensitive, that's protected by, if you are in a regulated industry especially, it might be protected by laws, by federal laws, by state laws. So the common ground that we found in reading about it is that the ones that are against or pro monitoring, they all agree that if it's the sense of fairness is present, if it's everybody's aware, then it's the chances of problems are going to be reduced. The thing is that in one research from by IDC, the International Data Corp, I have here with me, 110 businesses, only 45% of the respondents said that they knew about the policies, and especially about email. Most of the employees didn't know that the email was being monitored. So it is more about really ensuring that your firm is collecting data connected to the business purpose. It's about productivity, it's about protecting the client's data and so on, because that's what we, when I read about the incidents where firms, lawyers got in trouble because it was unclear. They were just collecting data because they could. And how they can, as we are talking about technology, do that. It's monitoring. They can use passive trackers or active trackers. So screen time, when people, employees are using the computer or when they are not using. And also, because the security tracking is happening to protect the data already, sometimes we might be tempted to tap into that information. But the goal of that security tracking is very explicit in the security policy, if you want to use that data, we want to ensure that whatever we have in our monitoring policy is using that data for productivity monitoring instead of just because I have the data, I'm going to use it, right? Biometric monitoring is another issue. I can monitor the camera if the camera is on, or if I'm using my thumbprints to activate the computer. But that data is very sensitive. So we have cases on the media where the cameras were all the time being monitored, and they captured intimate scenes in the employee's house, and they were in the middle of the information being gathered. Keyloggers, everything that you were typing might be being tracked. So, but is it working only during the working hours, or it is explicit that is the computer is owned by the firm, so whatever is being tracked is being keylogged. So also video surveillance. So everything that is I come from a cybersecurity background. So everything that we are collecting across the organization today there's a blurred line between physical security and cybersecurity. So all the cameras that you see, the physical cameras that are across the company, might be connected in monitoring software with whatever I'm gathering from cameras on the computers or what I'm monitoring through the computers. So how far should we go in connecting that and giving unlimited access to the IT people behind the monitoring functions, so that now it becomes a bigger thing, and it can really backfire if something goes wrong, and employees are going to lose trust. And this is one of the factors that is in the VMware survey, showing that especially the younger generation employees, if they feel that this trust is broken, they will go away, and then we have a turnover problem.
Thank you, Eduardo. There's a lot there, and certainly a lot to be mindful of, including what you ended with there, which is the importance of transparency so that you keep employees understanding what's going on and therefore keep them happy, and therefore you get to keep them employed.
Exactly.
Bernie, there are some other ways that technology is being used, perhaps to prevent lawyers from zealously representing their clients. And one example of that is facial recognition software that Madison Square Garden uses to control who can and cannot enter its building. And they used it to prevent lawyers from entering under the claim that they were trying to prevent the lawyers from illicitly gathering information for their cases. Can you tell us what happened there?
Sure. This is it's a fascinating and colorful case that is mostly about property law with a legal ethics sidecar. So in order to understand the legal ethics sidecar, we've got to get the property law out on the table. As Max explained, Madison Square Garden Entertainment, basically owned and run by James Dolan, began to use facial recognition technology to exclude lawyers representing clients suing any of the organizations that operate their properties, which is it includes Madison Square Garden, Radio City Music Hall, a whole lot of restaurants and theaters, and now also the very fancy Sphere in Las Vegas, which costed $2.3 billion to build and is apparently quite a showplace. How do they do it? They had facial recognition software that they were using to exclude former bad customers, people who drank too much, got into fights, that kind of thing. And they started gathering the names of the lawyers and law firms that were suing them, went to their websites, got photographs of all of the lawyers, fed them into their facial recognition software and had it alert all of the gate agents, or the gate agent where someone was standing at the door, that a lawyer who was on the lawyer exclusion list, which is what they called it, was trying to come in, and part of the gate agent's job is to say, "I'm sorry, you can't come in." A number of the lawyers, particularly some personal injury lawyers, sued Dolan and the companies operating as properties to enjoin the continuation of this policy. So the question is, what's wrong with excluding lawyers from coming into an otherwise public venue? And that turns out to be a lot harder to talk about than you might think. If you think back to your first year property course, and I know it hurts, but work with me. You'll remember that an essential feature of property, what you might call the central stick in that bundle that people use to metaphorize the notion of property, is the right to exclude other people from your property.
I just had flashbacks, Bernie. Thank you.
I have some antacid if you'd like some. I'm pleased to say I don't teach property. So you start from the proposition that the right to exclude is absolutely essential and indivisible from the notion of owning a physical place. There are reasons that you can not exclude lawyers or not exclude any people from your property, but there's specific exceptions in the law. For example, you can't exclude members of a protected class on a discriminatory basis because of all kinds of public accommodations legislation. You can't exclude law enforcement that is properly exercising their duties when they come onto your land to do something that they're supposed to do. But lawyers are, to put it mildly, not a protected class. And so it's hard to think of a reason for excluding. Now, we can all think of lots of really good reasons why you might want to voluntarily exclude someone, like what Madison Square Gardens was doing between 2018 and 2021, which was excluding people that had a record at the property of fighting, vandalism, hooliganism, creating disturbances in a theater during a performance. Looking at you, Lauren Boebert. I think a lot of people who go to these places would agree that people like that ought to be excluded to make those venues safer and more enjoyable. The justification, well, let me come back to Dolan's justification. The lawsuits initially went well and then went badly. What first happened was courts were at a loss to understand what basis you could use to exclude lawyers, and that was the specific injunction that was sought. But it turns out most of Dolan's properties are in New York, and there is a 1941 law on the books in New York that forbids denying admittance to, quote, legitimate theaters, burlesque theaters, music halls, opera houses, concert halls, and circuses, with exceptions if somebody's being abusive or offensive. This actually came into effect because a very famous theater critic, his name was Leonard Lyons, was excluded from all Schubert family theaters in New York. And his friends pushed a bill through the New York legislature, allowing him to get back into those theaters. It doesn't include sports venues. And Madison Square Garden is very much a sports venue. So how is this fared in the courts? At first, the New York trial courts enjoined this, saying that either it violated an anti-discrimination law or this Lyons law about forbidding people entrance to entertainment sites. Basically saying you can refuse to sell somebody a ticket because you're free not to do business with anybody except discriminatorily. But you're not allowed to exclude someone who's holding a ticket from coming in, because that's what the Lyons law is supposed to do. The appellate division reversed that preliminary injunction, and a penalty that had been for contempt that had been assessed by the lower court pursuant to it, saying that the preliminary injunction was overbroad. That case has settled, and a lot of the plaintiff side firms that have been suing MSG about the policy have also settled their cases, recognizing that the appellate decision is a very big step in Madison Square Garden's direction. So is there a legal ethics argument here? Yes. Dolan claims, as Max pointed out, or I think it was George, that the purpose of his policy is to prevent people from gaining unfair and illicit investigation advantage by buying a ticket, coming into his venues, and looking at the place where their client fell down or was assaulted or whatever. These are a great many of these are premises liability cases. So that doesn't really stand up to scrutiny. Why? Because the general rule is lawyers are not forbidden to conduct ordinary investigation in any place that the general public is allowed to go. And in fact, if you read the cases about investigation, they generally articulate a policy favoring legal investigation, so that law firms that are lawsuits that are brought are properly grounded in fact. So that's a very limited and probably probably something that doesn't deserve to be taken seriously. But when you start talking about barring hundreds of lawyers from massively popular public venues, it becomes, to a lot of people's taste, kind of creepy. How come?
So Bernie, I'm going to jump in and thank you. We're going to move on.
Okay.
Before we get too far down this particular rabbit hole, I want to ask George if you can talk briefly about another technology point, payments, and how payments are made to lawyers, and ways that lawyers should be cognizant about their ethical duties as they accept electronic payments.
Sorry I went on so long.
It's quite all right. It is a fascinating point.
So I'm going to be brief. This material is covered on slides 50, 51, and 52. The bottom line here is that we have to think about the bedrock principles of Model Rule 1.15 regarding handling client funds. We don't commingle client funds with our own funds, and we always place unearned funds into client trust accounts. The problem that arises here with credit card transactions is you have to set up a special credit card account for attorneys, because otherwise the transaction processing fee will be taken out of each payment that is paid by Visa, MasterCard, American Express, or Discover, or whatnot. Instead, the arrangement with the credit card processor for the attorney needs to deposit client funds in a client trust fund at full value without deducting any kind of processing fee. and instead take the processing fee from the lawyer's operating account. This is in the case of funds that haven't been earned yet. If the fees have been earned, they can be wired directly into the operating account, and the transaction processing fee can be used. Also, it's at least a cautionary note, if not a complete prohibition, on using systems like PayPal, which don't actually deal with the transfer of monies through the banking system, as the Visa, MasterCard, and American Express do. Under PayPal's arrangement, you're only coming up with a contractual right to go against PayPal's accounts, and therefore we're commingling funds into a non-client trust account when PayPal gets those funds. I won't belabor the point anymore, but you've got to be careful, and remember, thou shalt not commingle.
Thank you, George. Words to live by.
It's sometimes referred to as the third rail of legal ethics.
Indeed. So we've got just a few minutes left, which is, no matter how many minutes we had left, would not be enough time for this last topic we're going to cover today, which is generative artificial intelligence. Katie, can you begin this conversation and give us a little amuse-bouche about AI, and then we can talk about it more perhaps at another time.
Yeah. You could, I'm sure, do an entire series on this and still have enough material left over for another 6 episodes. But extremely briefly, when we're talking about AI issues lately, we are talking about generative AI, which is a difference in kind more than degree of AI issues. And excuse the background noise.
Quite all right.
AI tools are not new to the legal industry. If you've been a litigator in the past 10 years, you've probably run across e-discovery tools, which have certain facets of, advanced algorithms that can search out the type of information you're looking for that is going to be relevant to your case. We also have other, auto text prompts and things of that nature in Outlook or in other Microsoft products. There's spell check that can be considered AI in certain circumstances. Generative AI is a whole different animal, which is taking large data sets and analyzing them and then producing new information in response to queries that you're putting into a prompt. ChatGPT is obviously the most familiar of these tools that's being used right now. When it comes to using these tools for our legal work, again, we just have to go back to the basic principles, the framework that we've been talking about, and apply it to this new technology, which is challenging, but it's doable. We have to keep in mind confidentiality issues. If you're going to be putting queries into a ChatGPT prompt or another type of generative AI tool, you need to make sure that you're not putting confidential client information into that tool. This is a third-party application, and unless you have some sort of enterprise software agreement that's going to put guardrails around the security of that information and make it and maintain its confidentiality, you could be inadvertently disclosing client information to a software system that's going to be learning from it. You can't put in someone's trade secret information or other confidential information belonging to your client and provide it essentially to another company to use for its own learning models as it's training its AI. You might inadvertently risking privilege if you're doing things of that nature as well. There's also supervisory responsibilities you have with this to make sure that the other people in your firm are complying with the same policies that you're putting in place. There's issues of competence. You need to know how this is working, and you need to make sure that what you're getting out of the AI tool is accurate. Everybody has heard of the filing, famous around the world by lawyers who filed a brief that had fake citations in it because they had used ChatGPT for their legal research. You have to be competent in both the use of this tool and in relying on the outputs generated by it. That would also involve our duty of diligence, and in that case, the duty of candor towards a tribunal, because the attorney was not forthcoming about the source of the citations that were used in that brief. That's obviously an extreme case, and I'm hoping most attorneys are not going to misuse generative AI tools in that manner, but there are issues that you might not consider in using these tools if you're not abiding by your duty of competence and diligence and understanding what these tools are doing and how they're using this information. The Florida Bar Association has recently put out a proposed advisory opinion about the use of AI in client work, as well as the California Bar Association. They've put out some guidelines that are actually really helpful. It breaks down in a table the different rules that are implicated by different uses of AI. And so I would advise everybody to go look at that, particularly the billing guidelines, which, are advising attorneys to make sure that they're not charging clients unnecessarily for work that is made faster by AI. This will be a tool that most of us are going to use in the next 5 to 10 years, and we should understand how to use it effectively, ethically, by maintaining our clients' confidentiality and, making sure that we're not avoiding it either to bill higher or, misusing the technology to speed up our work, but still charging, for what it would have taken me to do it without AI. So very
Indeed.
small introduction.
Exactly, a very small introduction. I think it is amazing. It's fascinating because the fact that generative AI would make up cases makes perfect sense once you actually understand what generative AI is doing. So you feed in a bunch of publicly filed briefs, the AI tool looks at that and says, oh, this kind of writing often has a few numbers followed by an F third, followed by some more numbers. I'll just make up new numbers. And I'll put a name next to it with a V in between the two names. That's how these people write. The tool has no knowledge as to why we write that way, or that there's actual independent significance to that sequence of numbers and letters. And so it just spits out new ones. And it makes perfect sense once you begin to have a small amount of knowledge about how the technology works. To close us out, though, Eduardo, I want to offer you the opportunity, since you are actually our resident tech expert, to add anything you might want to add to all of this.
Thank you. Fascinating. I always learn participating in these panels from my peer panelists. What I wanted to share is that no matter what is the technology, the message that George started in the beginning, we have, and Max, we have to go back to the basics. It's the rotation, job rotation. It is ensuring that we have more than one person doing the same work, having the basic controls in place, and AI, or whatever is the next tool that is going to be the brouhaha. It's whatever we will have ahead of us. We will always have to rely on those basic controls. If it is the big thing now that we will likely cover in following panels is deep fakes and AI and all the issues that can happen. Brilliant marketing people trying to create deep fakes with the best intentions just to help the clients, but what are all the liabilities that come together? So that's how I wanted to close. And instead of looking for the very sophisticated solutions, we should really look back at the basics.
Well put, Eduardo. And I like the fact that we give the tech guy the opportunity to close us out. And he's like, go back to basics, which is exactly right. Thank you, everybody. This concludes our webinar. Thank you for joining another entertaining yet educational production of Financial Poise. Look for Financial Poise webinars wherever better continuing education webinars are sold.